The Law and You, a look at laws in St. Vincent and the Grenadines which affect our daily lives. The Law and You, presented by lawyer panel P.R Campbell QC and brought to you on SVG-TV as a public service.
Ladies and gentlemen, brothers and sisters, boys and girls, greetings. Welcome to another presentation in this public service nation-building series, The Law and You. This is program number 964, coming to you on Monday the 24th of February 2020. On this program, I will speak to you on the topic Equitable Interests. And as usual, my condolences go out to all families which have suffered recent bereavements, particularly those caused by violence. And my heart goes out to the family of the young gentleman who was killed over the weekend, Saturday night, the relative of our Bishop Godfrey Haywood of North Union. My sympathy, Bishop. Let me welcome the Court of Appeal to St. Vincent and the Grenadines for its February sitting. They would have started this morning and they will sit for the week, and they will not be back in St. Vincent for another sitting until the 15th of September. I noticed something strange about the list of cases before the Court of Appeal, because the court office posts the lists on the website, and all lawyers and persons who wish to go on the website can see the cases which have been set down to be dealt with by the Court of Appeal this week. And it was surprising to me when I perused the list that I didn't see any mention of the election petition appeals. I have made some inquiries, and I understand that in all likelihood the appeal would be down for the September sitting. But the implication of that politically is that, to all intents and purposes, those election matters are now, well, if not irrelevant, have been overtaken by time, because if the appeal is heard in September, one cannot expect a decision until, at the very earliest, October. Now, if the court rules that the elections in North Windward and the Central Leeward were so badly tainted that the seats have to be declared vacant, it would be too late for anything to happen other than a dissolution of the Parliament. Because following such a ruling, the government would have 90 days to make up its mind whether to have by-elections or a by-election, depending on the outcome, if the ruling goes against the government, or whether to call general elections. So to all intents and purposes, the election matters are off the political agenda, which is a great pity. Let me, however, get into the topic for the evening, equitable interests. A bit of a mouthful, a highly technical phraseology, and I will not go into the technicalities, but I will devote myself to giving some of the main examples of equitable interest. Now, Equitable interests, referring to property, are to be distinguished from legal interests. A legal interest means that the person who has that interest has a right, an absolute right. Whereas a person with an equitable interest in property has a qualified right, not an absolute right. Now, I know that sounds a bit confusing, but as I go along, I hope to illustrate the difference and to show you the importance of the recognition of equitable interests in property. Let me start with a usual example. Let us say a person has a title deed to a parcel of land. And for the sake of illustration, let us say a parent or parents have a title deed to a parcel of land. So they have the legal interest in the land. The land is legally theirs. Let us suppose that those parents give permission to one of their children to build a house on a spot on that land without executing a deed of gift to give the house spot to that child. In other words, parents have a fairly big piece of land, and one of the children gets of age and says to the parents, "Can you allow me to put up a house on a corner of the land?" And the parents naturally, once the land is big enough, the parents naturally would be happy to know that that child is trying to make headway in the world and trying to make something of his or her life, and would naturally say, "Sure, go ahead." Now, no paper is signed. I'll come to that just now and show you why you really should get paper signed up. But in the usual case, there's no paperwork, just word of mouth. The parents say to the child, "Yeah, you could go ahead and put something for yourself on a piece of the land." What the parents would have given that child is an equitable interest in that piece of land. The child cannot go and sell it because he or she hasn't got a deed for it. And you can only sell land for which you have a deed. But by the same token, because the parents who own the land give permission to a child to build on the land, no other member of the family can't chase the child off and say, "Well, go on, is daddy land?" No, because daddy has given permission. Therefore, the parents who have the legal title to the land, or in other words, they have a legal interest in the land, would have given that child an equitable interest, meaning certain rights not amounting to full ownership. The practice is very common in Caribbean culture. So much so that you will find several houses, a cluster of houses on a piece of land. You have the main house belonging to the parents, who may be alive or dead, and 2 or 3 other houses on the same smallish piece of land belonging to 2 or 3 children who have got permission from their parents to erect those houses on the parents' land. In other words, the parents would have given equitable interests to their children to permit them to build. This, as I've said before, happens quite frequently in our system. But it causes confusion in many cases. There confusion having to do with boundaries, confusion having to do with the provision of services, confusion as to the yard space which each house is supposed to be entitled to. Now, these are days when it is not enough for you to have a building on a piece of land. You want a title deed. The title deed gives you security to that piece of land and enables you to go to a lending institution and say, look, I would like to borrow some money to improve this house, put on an addition or fix up the downstairs or the upstairs as the case may be. Here is my deed. But that can only happen if a parent who has given you permission to occupy that piece of land with your house, if the parent has also given you a deed of gift to that piece of land. Then the position gets more complicated when a parent gives permission to a child to build a structure on a piece of the parent's land. That child gets in with a common law companion. In fact, the child may well have been in a relationship before getting the piece of land. The common law companion assists the child in building a house on the spot of land given by the parent. Then the common law relationship goes bad, breaks down, parties split up, and the companion of the child who has been told to leave says, well, how could you ask me to leave when I have money in that house on the land? I have my money in it, I have labor in it. Now, it's difficult for that person who, let us say, has been thrown off or evicted or who has been attempted to be evicted, difficult for them to go to court and get anything but an order declaring what are their rights. If they can overcome the hurdle of proving what they put into the building of the structure. So that whenever parents, or anybody for that matter, have a parcel of land and want to give permission for somebody to build on it, the party should get a lawyer to draw up the proper papers for them to sign so that everything could be in order. Sadly, in the vast majority of cases, there is no paperwork at least none done by a lawyer. And when disputes arise, they have to go to court with all the attendant expense and stress and turmoil that can cause. So the advice I am giving to persons who are minded to permit somebody to build a structure on their land is to get it done in the proper legal manner. Get a lawyer. The first thing the lawyer may advise is, look, get a surveyor and survey the little subparcel which is being given to you or over which you have been given permission to build. Get a plan for it so that at least the boundaries of the land are clear and will not cause a problem down the road. Excuse me. One major complicating factor occurs whenever someone dies who has given permission to someone else to occupy a parcel of the deceased person's land. And there are no legal documents of title or no legal documents of any kind. The first hurdle is proof of permission. That is, anybody who is interested in going to court will have to prove that he or she had got permission to build on that particular spot. Now, in days gone by, people who got permission to build on somebody else's land would normally have been expected to put up a board house. And the old expression we used to use is you put up 4 sticks, meaning you put a board house on the land. A board house is regarded as a chattel, not as part of the land. Nowadays, you hardly find anybody erecting a board house. Hardly. Most people want a concrete structure. That creates a problem because a structure made of concrete on land is regarded as part of the land. It is regarded as a permanent dwelling, unless you put it up to make a little shop or a little parlor. But if you're going to live there, it's a permanent dwelling. Now, it doesn't make sense at all for anybody to put a wall structure on family land without having some sort of paperwork giving them the right to do that. Doesn't make sense at all. You're simply putting up a problem for later on. And if the problem doesn't confront you, later on it might confront your children when you die. So for heaven's sake, if you're going to spend money to put up a concrete structure on anybody else's land, do it by the proper method, by having a legally binding agreement drawn up by a lawyer. Otherwise, you could find yourself with all sorts of worries. But where the law would help you is if you can prove you had permission to build on the person's land. And you cannot go to court and say, you got permission from your auntie if the land belonged to your uncle. It's the owner of the land who has to give you permission. And if the owner has gone away, Canada or England, America, and has left somebody in charge of the land, the person who was left in charge may not necessarily have the legal right to give you permission to put anything permanent on the land. So that you can't go into court and cite someone as the person from whom you got permission unless that person either owned the land or had authority to grant you permission to occupy part of the land. But if you can prove you had permission, then that permission would constitute an equitable interest. Because a person is not allowed to give you permission to put a permanent structure on his land. When I say his, I mean his or her. And then when you have put up the structure, turn around and say, aha, that structure is mine because it's on my land. No, they can't have it both ways. But if they didn't give you permission, then they can go to court and ask the judge to put you off. And say, look, you had no right to put a wall structure on my land because I never gave you permission to put it there. However, and this is where a technicality creeps into that scenario, even if the person didn't give permission directly, the fact that the person stood by and looked at you put up the structure without making any objection could mean that if it goes to court, the judge is entitled to say, well, listen, you saw the person putting up a wall house on your land. You said nothing. So you encourage the person to believe that it was okay for them to erect the structure on your land, probably because of the relationship between you and other things. So you cannot keep silent and look at somebody do something on your land that would have a lasting effect. And when the person is finished and has spent a lot of money, turn around and say, I am claiming that because I never told you to go ahead and build. But by the same token, you never stopped them when they were building, when you had the chance to do so, because you might have living on the same piece of land and saw when they started the foundation, put up the first columns, cast the ground floor, put up supporting columns, run blocks, put on roof, and you're there saying to yourself, I ain't saying a thing, let it go ahead. And when time come now, you claim, no, the judges say, conscience, the court of equity, which is the court of conscience, cannot allow you to stand on your legal rights when you had the opportunity to stop the person doing what they were doing. The person might even be able to show that you not only stood by silent, but that you actually encouraged them. You might have helped to mix up cement. You might have helped to hand up blocks, provide food for the workmen. In other words, you can't be allowed, or the law does not allow you to stand on your legal rights if you have given equitable rights to somebody else to share your legal rights, or to at least interfere with your legal rights. No. To go back to the point I made at the beginning, all of that could be avoided if you go to a lawyer, explain to the lawyer what you all have agreed or what is intended. The lawyer will advise the best way it should be done. The lawyer will get something drawn up. Everybody sign, and in future everybody knows precisely where they stand. Very fascinating. Okay. That is all from this topic, equitable interest. I hope I have stimulated your imagination, but above all, whenever you have these intentions and discussions, take them to a lawyer to get it done in a proper manner. A stitch in time saves 9. Okay? All right, that is all from this program of the Law and You, program number 964. I look forward to being of further service to you next week, Monday DV, for another presentation in this public service nation-building series, The Law and You. Do have a pleasant week, ladies and gentlemen, brothers and sisters, boys and girls, and may the good Lord continue to bless us all.
The Law and You, a look at laws in St. Vincent and the Grenadines which affect our daily lives. The Law and You, presented by lawyer panel P.R Campbell QC, and brought to you on SVG-TV as a public service.